day. So today we're going to talk about the exemption, the hearsay rule, section 45 to 50. So first, we're going to talk about section 45. Section 45, records of regularly conducted business activity. A memorandum, report, record, or data compilation of acts, events, conditions, opinions, or diagnoses made by writing, typing, electronic, optical, or other similar means at or near the time of or from transmission of supply of information by a person with knowledge thereof, and kept in a regular course or conduct of a business activity, and such was regular practice to make the memorandum, report, record, or data compilation with electronic, optical, or similar means, all of which are shown by the testimony of the custodian or other qualified witnesses, is accepted from the rule of hearsay evidence. So, meron tayong ditong mga requisites based on the old rule under section 43, stating that number 1, the person who made the entry must be dead or outside the country or unable to testify. Dapat yung gumawa ng entry is patay na or nasa ibang bansa or hindi kayang mag-testify. The entries was made at or near the time of the transaction to which they refer. Number 3, the entrant was in the position to know the facts stated in the entries. So dapat alam niya yung mga kung ano yung facts na nilalagay niya sa entries na ginawa niya. And the entries were made in his professional capacity in the performance of a duty, whether legal, contractual, moral, or religious. So dapat yung entries na ginawa niya is in his professional capacity in the performance of his duty, whether it is legal, contractual, moral, or religious. And the entries were made in the ordinary or regular course of business or duty. So under the amended rule, it is no longer required that the person was made entry must be dead or outside the country or unable to testify. Also, sinasabi din dito na the entries are not only just made at or near the time of transaction to which they refer. Ngayon, they refer to memorandum, reports, record, or data compilation na ginawa ng person. And similar to the old rule, kailangan din na yung gumawa ng entry is merong knowledge about the facts stated in the entries. So, reason for admissibility is what a man has actually done and committed to writing when under obligation to do the act is being in the course of business he has undertaken, and he being dead, there seems to be no danger in submitting to the consideration of the court. Example is the baptismal certificates. So, baptismal certificates are admissible as entry in the ordinary course of business. Kahit na wala yung officiating priest or official recorder to testify, dahil nga it is their duty or is made during his performance of duty, kino-considered itong or it is admissible as evidence and hindi hearsay. Section 46, entries in official record. So, this is the presumption of regularity in the performance of official duty. Dito example dito yung mga situation na instead na magte-testify yung public officer ay gagamitin na lang yung official record. So there are requisites for the admissibility of the entries in official record. So first requisite, the entry was made by a public officer or by another person specially enjoined by law to do so. So, ibig sabihin, ina-allow sila ng law na gawin yon. Number 2, it was made in the performance of a duty specially enjoined by law. And third, the public officer or other person had sufficient knowledge of the fact by him or her stated, which must have been acquired by the public officer or the other person personally or through official information. So, before natin discuss further, i-define muna natin kung ano yung official record. So, official record, ito yung the original document that is legally recognized and thus ensuring the quality of the fact when it is established. So, example nito is yung police blotter. So, example scenario, si Police Officer A is gumawa ng police blotter about the case of Juan and Pedro. So, after ginawa ni Police Officer A yung blotter, namatay siya. Ngayon, pwede ba natin gamitin yung police blotter na ginawa ni Police Officer A kahit na hindi na siya makakapag-testify sa court? So, sinasabi dito sa Section 46, pwede natin gamitin yung police blotter na ginawa ni Police Officer A. Under the third requisite, sinabi dito na the public officer had sufficient knowledge of the fact stated and which have been acquired by the public officer or other person personally or through official information. So, ginawa niya yung blotter na meron siyang personal o sufficient knowledge about the facts na pinaglalagay niya doon. And under the requisite to din, sinabi din na it was made in the performance of duty. So, ginawa niya na rin naman yung police blotter in the performance of his duty. And sa first requisite, sinabi din na it was made by a public officer or by other person specially enjoined by law to do so. So, parang it is allowed by the law na gawin ni police officer yun. Kaya pwede yung gamitin yung blotter kahit na hindi na makapag-testify si Police Officer A sa court. So, next, Section 47, Commercial List and alike. Evidence of statement of matters of interest to persons engaged in an occupation contained in the list, register, periodical or other published compilation is admissible as tend to prove the truth of any relevant matter so stated if the compilation is published for use by person engaged in the occupation and is generally used and relied upon by them therein. So, there are following requisites for its admissibility. First, the statement of matter of interest to persons engaged in an occupation. Second, statements must be contained in the list, register, periodical, or other published compilation. And third, compilation is published for use by person engaged in that occupation. And fourth, there is such generally relied upon them. So, before we discuss further, let's try to define commercial list. So, commercial list, it is journals, list, and other publication and similar written or published works carefully researched or investigated, specially prepared, used in certain trade, industry, or profession, or even the public which rely on them. So, dito, example is meron tayong tinatawag na SCRA or yung Supreme Court Report Annotated. So, dito kinukompile yung mga case na desisyonan na ng court. So, example, meron yung attorney na nag-cite sa SCRA or cited a case na nakapaloob dun sa SCRA. So, yung case na yun is sinite niya as a basis to support his or her argument. Ngayon, it is considered as evidence and not a hearsay kahit na hindi siya yung author o nag-publish sa SCRA. So, let's try to differentiate the entries in official record and entries in the course of business. So, in the entries of official record, sinasabi dito na a private individual or the entrant must have acted pursuant to specific legal duty. So, sa entries in official record, ginagamit lang siya sa legal duty, especially enjoined by law. Pero dito sa may entries in the course of business activity, is sufficient that the entrant made the entries pursuant to duty, be it legal, contractual, moral, or religious. So, ginagamit din siya sa contractual, moral, or religious. Next, sa entries in official record, sinasabi na it need not be dead or unable to testify. Na yung entrant natin ay hindi kailangang patay na o hindi kailangan na hindi siya pwedeng mag-testify. While dito sa may entries in the course of business, sabi na the entrant must be dead or unable to testify. So next, sinasabi sa entries of official record na need not be authenticated kahit na hindi doon authenticate yung record. And dito naman sa may entries in course of business, kailangan daw merong authentication. So, yun yung difference nung dalawa.
Section 48, Rule 130. Learn treatise. It is a published treatise, periodical or pamphlet on a subject of history, law, science, or art is admissible as tending to prove the truth of a matter stated therein if the court takes judicial notice or a witness expert in the subject testifies. These are the requisites for the admissibility of learned treatises. 1. When the court can take judicial notice of them. 2. When an expert witness testifies that the author of such a recognized expert in that profession. Section 49, Rule 130. Testimony of disposition at a former proceeding. It is a disposition or testimony of a witness deceased or out of the Philippines or who cannot, with due diligence or otherwise unable to testify, given in a former case or proceeding judicial or administrative involving the same parties and subject matter. These are the requisites for the rule on former testimony to apply. 1. The witness is dead or unable to testify. 2. His testimony or deposition was given in a former case or proceeding, judicial or administrative between the same parties or those representing the same interests. Number 3. The former case involved the same subject as that in the present case, although on different causes of action. For example, siya ay nasangkot sa parehong kaso ngunit iba't iba ang kanyang dahilan kaya niya ito nagawa. Number 4. The issue testified to by the witness in the former trial is the same issue involved in the present case. Number 5. The adverse party had an opportunity to cross-examine the witness in the former case. The reasons for admissibility. The reasons for the admissibility of testimony taken at a formal trial or proceeding are the necessity for the testimony and its trustworthiness. Grounds which make a witness unable to testify in a subsequent case. Number 1, death. Number 2, insanity or mental incapacity or the former witness loss of memory. through old age or disease. Number 3, physical disability by reason of sickness or advanced age. Number 4, the fact that the witness has been kept away by contrivance of the opposite party. Number 5, the fact that after diligent search, the former witness cannot be found. Proof of former testimony. Number 1, if reduced to writing, such writing is the primary evidence thereof and should be used. Number 2, the stenographic notes or copy thereof. Note, the judge's notes are not evidence of what the witness said. They can be used only to refresh the memory of a witness. Okay? Section 50, Rule 130, Residual Exception. A statement not specifically covered by any of the exceptions having circumstantial guarantees of trustworthiness. It is admissible provided the conditions under Section 50, Rule 130 are present. Requisites for admissibility. The statement having equivalent circumstantial guarantees of trustworthiness must not be covered by any of the foregoing exceptions. Number 2, the statement is offered as evidence of a material fact. Number 3, the statement is more probative on the point for which it is offered than any other evidence which the proponent can procure through reasonable efforts. Number 4, lastly, the general purposes of these rules and the interest of justice will be served by admission of the statement of evidence.